Hi, everybody. My name's Paul Henman, and I'm talking to a small group of people in our room, and we've got a number of people online. It's my pleasure to welcome Associate Professor Yee-Fui Ng, who is an Associate Professor and the Deputy Director of the Australian Centre for Justice Innovation at Monash University. And you're coming to talk about a very important topic about automated decision-making in government, which we just had a Royal Commission about. So I think it's very timely. Did you want to know about who's in the room and wanted to find out what their interest is in the topic, or do you just want and then present? We don't have any slides, so
yeah, sure.
Yeah.
Who's in the room?
So, Caitlin, do you want to start by just saying briefly who you are and your interests in the topic?
Hi there, nice to meet you. I'm Caitlin Curtis. I'm in the Center for Policy Futures. I'm very interested in public perception of automated systems, especially artificial intelligence, and contrasting that with the AI creator community perceptions of the risks and benefits of the same systems.
Right.
Thanks, Caitlin. Kobe?
Hi, Kobe. I'm a reformed academic who used to write on this stuff. Thanks.
Subhadeep?
Hi, I'm a master's student and researcher with Paul actually at Yee-Fui, who's interested in AI systems and their impact on society more broadly. And I come from law and science and as a background.
Thanks, Subhadeep. Jake?
Hi, my name's Jake Oldenfein. I'm an academic at Melbourne Law. Thanks.
Thanks, Jake. Ryle? Oh, we got more people than I anticipated.
Hi, yeah, I'm a PhD candidate over at QUT, and I'm just looking at this idea of rationality in automated decision-making systems, and so I'm just keen to hear the discussion today.
Thanks, Ryle. Great to have you. Ben?
Hi, Paul. My name is Ben Retschlag. I'm a PhD student at UQ. I'm a philosopher and ethicist of technology, and I look at risk and distributed justice with automated systems and artificial intelligence.
Thanks, Ben. Tegan?
Hi, I'm a lecturer in the QUT Law School and a postdoc research fellow. And I'm interested in AI governance, particularly the concept of contestability. So yeah, I thought maybe if there was some coverage of that, I might come along today.
Thanks very much, Tegan. Chloe? Are you there, Chloe? We'll move on to Andrew.
Hi, everybody. My name is Andrew Whelan. I'm a sociologist at the University of Wollongong, and I'm interested in how automated systems interact with conventional bureaucratic systems and reproduce some of the kind of tragic calamities that fall from organized irresponsibility in bureaucracies. That's me.
Thanks, Andrew. Rita?
Hi, my name is Rita Maturanita. I'm a senior lecturer at Macquarie Law School, and one of my projects is on AI in government sector. So I thought maybe I'll hear something interesting during this presentation. Thanks, Paul.
Thanks, Rita. Is it Jean Quang?
Yeah, it's Jing, I guess.
Hello. Hi, Paul and everyone. Sorry, I'm a PhD student at the Melbourne Uni. Sorry, I got the COVID, so sounds a bit foggy. My research is about the examining the regulatory issues in algorithmic decision-making systems. I'm particularly interested in welfare systems and to see how the use of AI and data analysis will impact welfare recipients' benefits. Thank you.
Thank you very much. Now, in the room.
I'm Graham Moore. I've got an office next door and I'm a friend of Yee-Fui, so I came over for this, but I did a lot of politics, so I'm sort of interested in the idea of accountability, particularly systems and ministerial responsibility when things are so hard for ordinary folk to understand what these systems even are.
Thanks, Graham. And
I'm Samara. I'm doing a Masters of Governance and Public Policy, and I'm also working at the Australian Strategic Policy Institute. And yeah, I'm just really interested in like cybersecurity and tech policy specifically. So I thought this would be really interesting.
Yeah, thanks for coming.
And I'm Paul Henman from the School of Social Science in the University of Queensland. So it's great to have you here. I've just realised that the webcam is here, and if you wanted to stand here and record your visit, people can see who you.
Yeah, I think I'm better go in front of the
I'll leave you to it. Well, I think you wanted to talk about 45 minutes, and we've got plenty of time. Do you want people to interrupt you while you're talking?
Yeah, so if anyone's got any questions, feel free to jump in. Yeah, so
okay, well, I'll hand it over to you. So thank you.
Great. So good morning, everyone. Thanks for being here today and online. So basically, I've been really cold in Melbourne, so it's good to come here and have the taxi driver say it's down to 21 degrees. So yeah, it's a great pleasure to be here, escaping Melbourne's winter. And I'd like to thank Paul Henman for organizing this seminar, and Graham Orr as well for hosting me here in the University of Queensland, where I am enjoying the beginning of my sabbatical. So I also have to thank Fulbright, the Fulbright Foundation, for sponsoring my scholarship to New York University, where I researched about the digital welfare state. Professor Philip Alston was there. He was the former UN Special Rapporteur on Extreme Poverty, and he had a project there. So I benefited a lot from the Fulbright scholarship that is part of this book project that I'm doing at the moment. So I'm writing a book on automated government decision-making, looking at the US, UK, and Australia. And my presentation today will relate to part of a chapter of the book. And so basically we've got artificial intelligence and machine learning that have enabled widespread automation of government decision-making in Australia. Yet vulnerable populations have been very seriously harmed because of the difficulty that they face in challenging automated decisions. So in Australia, as we all know, the Social Security Automated System RoboDebt erroneously identified overpayments deemed to be owed by Social Security beneficiaries. And errors of methodology led to inflated debt calculations for over 400,000 individuals. So desperate people falsely accused of high debts rang the Social Security Agency Centrelink. They were put on hold for 8 hours. And these incorrect calculations have led to grave repercussions for vulnerable low socioeconomic debtors, including individuals experiencing severe mental health issues and even suicide. So in 2019, the federal court held that the basis for raising debts in the RoboDebt scheme was irrational and therefore unlawful. Following this, the Australian government agreed to settle a class action on behalf of 400,000 plus people affected by RoboDebt for $112 million without any admission of liability.
The judge that presided over this scheme decried the Commonwealth's handling of its online compliance system as a very sorry chapter in Australian public administration. And as we saw, the Robo-Debt Royal Commission's report that was handed down 3 days ago, and I do not recommend giving a talk 3 days after a 1,000-page report is handed down. It lambasted the scheme as an extraordinary saga of venality, incompetence, and cowardice. But this is not an isolated incident. So all the way across the globe, in Michigan, the Republican governor, Rick Snyder, a former venture capitalist who vowed to run government like a business, decided to put into place a new automated social security system and called Midas. And unemployment agency staff were laid off to achieve cost savings. And in their place, a $46 million automated fraud detection system was introduced in 2001, the Michigan Integrated Data Automated System, Midas. So Midas was programmed to treat any data discrepancies as evidence of illegal conduct and to trigger automated defaults, findings against all these individuals. And this program has been a huge windfall for the Michigan budget line. It collected over $60 million in just 4 years, and it brought the state budget back into the green. However, it turned out that the AI system had a 93% error rate. As a result, between 2013 and 2015, the system falsely identified more than 40,000 Michigan residents suspected of fraud. They seized their tax refunds, they garnished their wages, they imposed civil penalties, 400% of the amount the person is owing, plus interest. And all these people wrongfully lost access to their unemployment benefits, and they face fines up to $100,000. As a result of being wrongfully accused of unemployment insurance fraud, 1,100 people filed for bankruptcy. They lost their jobs, they lost their homes, they lost their livelihoods. So with a quadruple penalty plus interest, people went into significant debts. As their credit ratings plummeted, there was a stain on their record for 7 years. Consequently, they were unable to get jobs, rent houses, buy cars or homes. And a number of people committed suicide as well. So in a 2017 settlement, the Michigan Unemployment Agency agreed to stop using Midas's automated functions without human review. The settlement also made the agency reverse and refund certain fraud determinations. In 2022, so about 20 years after it first got introduced, the Michigan Supreme Court ruled that people in Michigan can sue the state agencies for monetary damages for violating their constitutional rights. In this case, it was the right of due process, which I'll talk about in more detail in a moment. So in the UK, there was the post office scandal where 736 sub-postmasters who ran the post offices were wrongfully prosecuted for theft, fraud, and false accounting in their branches between 2000 and 2014. The Post Office Limited, which was a wholly owned British government company, aggressively pursued these sub-postmasters through the courts, resulting in criminal convictions, at least 4 suicides. Some people were jailed, including a teenager and a pregnant woman, and many faced bankruptcy and financial ruin. However, none of them had done anything wrong. The Horizon accounting software system, designed by Fujitsu, had produced incorrect accounting shortfalls due to bugs, errors, and defects in the IT system that automated the post office network. Widely decried as one of the biggest miscarriages in British history, this multi-million-pound IT disaster has spanned over 20 years and generated widespread condemnation. So for each of these large-scale catastrophes to occur, deliberate choices were made at key decision points by elected politicians and senior public servants to procure and deploy faulty technology at a large scale on vulnerable populations. Hundreds and thousands of people were harmed for many years due to these very defective government decisions. We saw in the Robodebt Royal Commission that the department had legal advice from 2014 that the scheme was unlawful. But yet there was a deliberate and orchestrated campaign by the ministers, ministerial advisers, and senior public servants to conceal the scheme's illegality for the next 5 years and to undertake a media campaign to smear any welfare recipient who dared to complain. Consequently, although the unfairness, probable illegality, and cruelty of the scheme was apparent, definitely by the beginning of 2017, the scheme still persisted to the late 2019 before it was discontinued. So all these scandals across the world demonstrate the need to more closely scrutinize the regulation of automated government decision-making across the world, including how the system is designed, how AI technologies are rolled out, and what appropriate auditing practices are put into place to mitigate any potential ill effects. My book that I'm working on at the moment, therefore, examines the legal, political, and managerial controls that are needed to prevent these large-scale AI disasters from occurring. So what we can see from all these examples as well is that AI interventions, particularly in the social security sphere, are deployed experimentally and punitively. They have caused significant harm in various jurisdictions, including Australia, the US, the UK, and Netherlands. Welfare recipients have been used as test populations for technologies of state surveillance and control. So these invasive technologies have been deployed first on vulnerable populations before being rolled out to the broader population. So in this talk, I will explore the legal challenges to automated government decision-making in the US, UK, and Australia. The litigation tends to come from a different legal angle for each jurisdiction: constitutional due process in the United States, human rights in the UK, and administrative law in Australia. There are three main forms of challenging automated government decision-maker. So challenges to the input, output, and the use of the data. So first, a person affected by AI, the decisions made by AI could challenge the inputs to the decision-making in terms of faulty code or faulty data. The person can argue based on anti-discrimination principles that the data inputted into the AI system is biased and produces discriminatory outcomes. Another method is to challenge the outputs or the results of AI decision-making. So if they can show that the computer produces decisions that are substantively flawed. So this can be done through challenges of the rationality of the decisions in the United Kingdom or Australia, or due process in the United States, which considers the relationships between the inputs and outputs of government decision-making. Finally, another avenue is to challenge the use of the data in terms of data sharing and retention. So a person can claim privacy protections in the government's use, dissemination, and retention of AI data. So in this talk, I will focus on legal challenges based on rationality. I think someone in the audience was interested in rationality in particular as well. So a major legal issue, major legal avenue for challenging automated government decision-making is based on the concept of rationality. The legal system is predicated on the assumption that decisions are made by human administrators based on the concept of human rationality. So decisions that are made by computer that fail this concept of rationality can be subject to legal challenge. So the use of AI in welfare, in particular, in Western jurisdictions, has been plagued with problems of inaccurate or irrational determinations. For example, an algorithm used by the Department of Human Services of Arkansas would determine a foot amputee had no problems with his feet, despite lacking a foot. So really quite irrational decisions. So there are three main areas of concern when we talk about the reviewability of decisions. So what is seen to be constituting a decision? Who is the decision maker? And what are the grounds to challenge the validity of a decision? So the first question, what is a decision? So in determining what is a decision, the United Kingdom has adopted the public function approach based on the DataFin test, which means that the key issue is whether the body is undertaking a public function, which would make it immaterial whether the decision is undertaken by human or by AI. In the US, the focus is on the impact of the decision-making on the individual. That is, decisions that impact on a person's life, liberty, or property, with a very generous interpretation of the word property as encompassing welfare benefits as well. So this empowers individuals to constitutionally challenge government AI decisions that affect their fundamental rights. This has not been fully tested, but it appears that Australia is interpreting statutory judicial review under the Administrative Decisions Judicial Review Act by reference to the process of decision-making. So the majority decision in Comparative requires that a decision involve a process of deliberation. As the dissenting judge in the case noted, this may exclude automated decisions from its ambit because AI decisions lack a process of deliberation. So this may therefore preclude statutory judicial review of agency decisions. Another avenue of judicial review is constitutional review under Section 75(5) of the Constitution in Australia. And that hinges on the identity of the decision maker, whether the decision maker is an officer of the Commonwealth. And that may potentially create issues for AI-made decisions if the decision is wholly made by a computer. However, this can potentially be cured by a deeming provision, a legislative deeming provision that deems a decision made by a computer to be made by a minister or a senior government official. So therefore, the United Kingdom and the United States have a formulation for review that is more conducive to challenging wrongful government AI decisions, while Australia's approach may lead to issues in terms of reviewability. The second question is, who is the decision maker in an AI decision? So there's always been a presumption that an administrative decision will be made by a human. So there will be a responsible party. In the case of AI-assisted decisions, where the technology is used in the process of making a decision, but the human is the ultimate decision maker, this should not be an issue, as ultimately there's still a person at the end who's a decision maker. When it comes to fully automated decisions, however, it becomes less clear. So one option is to borrow from the European Union GDPR, the General Data Protection Regulation, and only allow for fully automated decisions in certain circumstances, such as where it's necessary to enter into a contract, is authorized by a law that provides sufficient safeguards to the person's data, or is based on the person's explicit consent. A further method of ensuring that there's a designated responsible party is by inserting legislative deeming provisions. So these are sections in legislation that say that a decision made by AI technology or the computer will be deemed to have been made by the minister or a senior public servant. So providing a responsible person for an AI decision facilitates judicial review, and it enables accountability over AI decision-making. Finally, there's a question of the comparative grounds of judicial review across jurisdictions. In Australia, in 2019, the basis for raising debts under the robo-debt program was held to be unlawful. In a test case by a debtor subject to robo-debt, the federal court in consent orders in Amato and the Commonwealth held that automated decisions made on the basis of income averaging alone, that is the robo-debt method, were irrational and therefore unlawful. In the case of Routledge and the Commonwealth, as I previously mentioned, the Australian government settled this big class action for 470,000 people affected by robo-debt for $112 million. And the Commonwealth government admitted that it did not have a proper legal basis to raise, recover, or demand all these asserted debts that were based on income averaging alone. So as a result, the courts found that the debts issued were ultra vires or beyond power, and therefore unlawfully incurred on the applicants on the basis of a mistake of law. So the Australian court's approach in robo-debt focus narrowly on the methodology of the decision-making that produced these inaccurate debt notices, rather than its substantive impacts. And this means that future automated decisions that are made on the basis of different data points may be held to be valid. By contrast, the approach of the UK courts holds greater promise for success in terms of judicial review for vulnerable claimants, because it focuses on the merits of the rule and its substantive impact. So the UK framework combines domestic judicial review with international human rights conventions that are incorporated into domestic law. Therefore, in addition to judicial review, the UK courts will consider the human rights grounds for the European Convention of Human Rights, or ECHR, which adds to the scope of review in terms of anti-discrimination and privacy, with successful challenges on those grounds. And this, therefore, scope allows for a broader scope of legal challenges of government action compared to Australia. So in the Secretary of State for Works and Pensions and Johnson, the UK Court of Appeal invalidated part of an automated system used to calculate universal credit payments. The automated system did not accommodate for the fact that people who are usually paid their salary on a particular day each month would be paid on a different day if the day of payment falls on a weekend or public holiday. And this caused major fluctuations in the amount of welfare payments that were paid. And the problem impacted a particularly vulnerable group, which is those who are on low incomes undertaking ad hoc employment. In this case, the plaintiff was a single mother that was at risk of eviction due to the major fluctuations in the welfare payments and lack of cash flow. And this led her to borrow money just to purchase food. One of the welfare recipients, who was also a single mother, reported that the system of fluctuating payments led her to go deeper and deeper into debt, and she felt so desperate that she attempted suicide twice. So the Court of Appeal invalidated the relevant part of the automated process and found that the regulations were irrational and therefore unlawful. This was because the issue had a dire impact on 85,000 vulnerable citizens, and it led them to suffer consequential financial stress. In addition, the court found that the processing of claims was arbitrary and claimants were not alerted by job center staff that the problems that we would face if the end date of their assessment period coincided with the day in the month that their salary was paid. Another basis of irrationality was that the system operated to disincentivize work, contrary to the legislative policy. The system created an incentive not to work to receive a stable income or to look for a job where the salary payday did not coincide with the end of the assessment period, which may take priority over a promotion or a higher paying job that made use of this claimant's skills and educational achievements. Indeed, one of the claimants refused the promotion because of the payment conditions. Therefore, in its decision, the United Kingdom Court of Appeal was willing to consider the substantive issues of the actual impact of the rigid rule on these vulnerable populations and whether the AI rule achieves its policy goals. And this led to the finding in Johnson that the minister's decision met the very high bar of being Wednesbury unreasonable. That is so unreasonable that no reasonable decision maker could have come to that decision. In the US, automated government decision making has been successful on the ground of procedural due process, which considers whether the government has followed the proper procedures when they take away a person's life, liberty, or property. For example, in the case of Michael T. and Bowling No. 2, a group of West Virginians with severe intellectual and developmental disabilities brought an action against the state's Department of Health and Human Resources, challenging the state's reliance on a proprietary algorithm to reduce Medicaid benefits, which was administered by APS, a private company. So the district court found that the APS algorithm did not satisfy America's due process constitutional requirements because the government had not provided any information about the factors that were incorporated into the algorithm, how each factor was weighted, and the overarching methodology that was employed. The court also criticized the APS for not providing an individualized rationale for the budgets that were allocated to the plaintiff, making it impossible for the plaintiff to meaningfully challenge the budget. So the court concluded that the APS decision-making process created an unacceptable risk of arbitrary and erroneous deprivation. As a result, the West Virginian government developed a new system containing matrices with clearly identified variables that would be publicly available. And the court concluded that the new system had sufficiently remedied the due process flaws and lifted the injunction. So in general, due process claims in the US have been successful based on the basis of insufficient notice or explaining why the AI tools analysis led to a reduction in benefits, which then created the risk of the determinations being arbitrary and erroneous. When an algorithm is used in decision-making, US courts have recognized that the individuals affected have to be provided with sufficient information about the decision-making process to ensure that the automated decision-making is accurate. Therefore, in the US, the focus of the cases is not only on the accuracy of the decision-making, as we can see in the UK and Australia, but it also focuses very strongly on broader transparency requirements. American due process claims provide safeguards to ensure there is some degree of disclosure of AI methodology. So although the due process right is flexible according to context, the minimum level of disclosure seems to be the static factors relating to the AI methodology. So some cases go further and require disclosure of the individualized basis of the decision. so affecting that particular person. So this public disclosure requirements enhance the transparency of AI systems in the United States, in providing the claimants with sufficient information to ascertain whether there has been any flaws in the decision-making process. However, the level of information has varied and has been criticized as being insufficient in some cases. For example, in State and Loomis, the Wisconsin Supreme Court upheld the use of a controversial algorithmic predictive sentencing tool used by judges. So the decision-making tool is used in a number of US jurisdictions to predict which offenders pose the highest risk of reoffending. So it's predicting whether they might commit criminal behavior in the future. So it is not known, however, how the complex risk assessment tool performs this task. This is because the tool itself and the algorithm upon which it is based remain a trade secret. Nevertheless, the Supreme Court of Wisconsin approved the use of such tools, provided that the judge didn't fully delegate their decision-making function and still considered the defendant's arguments on future reoffending. One positive feature in the US is AI litigation settlements or decisions may involve an ongoing system of monitoring and supervision by the courts for several years following the decision at the discretion of the judge. This leads to continually negotiated outcomes between the plaintiffs and government about the implementation of AI systems. So for example, in a case settlement for an automated decision-making formula for Idaho's Medicaid system, a roadmap was developed for how the state would fix the formula and provide a suitable representative for individual recipients. Over several years, the state had to provide information and updates on its progress on amending the formula to the court with consultation with the affected parties. This system of continual supervision after a decision is an additional form of oversight that ensures that the government implements adequate changes to AI systems. Therefore, it can be seen that automated government decision-making has been successfully challenged by way of judicial review in the United States, United Kingdom, and Australia. In the US, the challenges have been based on procedural factors, such as the level of information provided about AI systems. By contrast, in the UK and Australia, the substance of the decision is material. That is, whether the AI decision can be justified. However, the formalistic approach to legal interpretation in Australia that focuses on the process of decision-making and the nature of the decision maker is more likely to hamper legal challenges. On the other hand, the UK's broader rights-based approach that considers substantive issues relating to the impact on vulnerable populations and whether the AI rule achieves its policy goals is preferable to enable individual redress. The American concept of due process allows individuals to prise open the bonnet and to obtain disclosure of the details of the AI system. This, coupled with a proactive system of continual monitoring by the courts, allows for the strongest possibility for changes and corrections to government AI systems. To sum up, governments in liberal democracies have jumped onto the AI bandwagon, and they have been enthusiastic adopters of new technologies. However, the use of automation in government has often been trialed and deployed punitively on the most vulnerable sections of our society. to predict and punish criminal recidivism and unemployment fraud, and to automate social security debt notices. It's not been used to predict insider trading by the wealthy. So, so the then United Nations Special Rapporteur on Extreme Poverty and Human Rights, Professor Philip Alston, warned about the risk of the digital welfare state, where digital data and technologies are used to automate, predict, identify, surveil, detect, target, and punish. In this context, it's time to seize the gauntlet and to address one of the most significant problems of our time: how to ensure that automated government decision-making is implemented in a fair, effective, and accountable manner without harming vulnerable citizens. So thanks very much. That is the sad story, but the happy story is hopefully we can do better next time.
Wow, thank you very much. There were a number of cases there that I wasn't aware of, so I really appreciate you sharing those with us. We've got plenty of time for questions. I know there are a number of hands clapping up online. Any questions that people would like to? I've got some, but I'll wait to others to have a turn.
Yeah, Paul, thanks, Yee-Fui. It's Graham Moore here from UQ Law. So I guess I'm interested in thinking about this concept of vulnerable and fairness. I was just trying to explain the robo-debt system to my children, teenagers, and I was reminded that some parts would just look like just an automated version of something like, you know, withholding tax. So, you know, if you're a seasonal worker like my kids are, you work a lot in December selling ice cream, and then you pay quite a high rate of tax in December. We don't think that as vulnerable, although some people would be if they needed that money. And we would just say we wouldn't say that was irrational. But essentially, if you're an employer, you're being told by the tax office, follow this very strict flow chart to decide how much you withhold. Oh, and at the end of the financial year, kids and seasonal workers will get a big tax rebate. So I'm just trying to think about that idea of, yeah, vulnerability, but also that distinction, I guess, between, you know, what kinds of things we accept as just efficient flowchart design. We wouldn't say that withholding tax is irrational, versus those things that we would class as AI or automated decision-making, because in a sense, some automated decision-making is just making more efficient these flow charts that the regulatory law imposes on all society and including employers in this case.
Yeah, thanks a lot, Graham. So there is quite a lot of literature on vulnerability and disadvantage and what is classified as vulnerable. So like low socioeconomic, educational, where they live, that kind of thing. So there disability, and there are different types of vulnerability in different points of people's lives. So they might not be vulnerable now, but they might reach old age and become vulnerable. They might lose their job and become vulnerable. So there's sort of situational vulnerability. There's vulnerability that inheres in a person. So if you're physically disabled or mentally disabled or something like that. So there's a lot of different aspects of vulnerability. And yeah, you're quite right that the government has to impose a policy that applies to everyone. But yeah, the problem is where it disproportionately or very strongly negatively impacts on one particular vulnerable section of society, such that you can say that, 85,000 people are affected by this, and the government could have tweaked the rule to be a little bit less rigid, and that would have ameliorated the situation. So like, that in the UK example, Johnson putting that very strict paydays rule. So by tweaking a little rule, it doesn't break down the whole system of universal credit, but it ameliorates the effect on 85,000 people. So I think it is a balance between, efficiency of government decision making, but also that fairness for that individual or cohorts that are quite vulnerable.
Yeah. Post office franchisees, who wouldn't normally class them as vulnerable, they had a little bit of capital in there, but they were so, because the criminal act sanctions things, as well as the false you owe us money now thing, put them into a situation of clearly due process unfairness and vulnerability. So, and that's is the kind of thing where people start to think, well, this is an unaccountable black box, Kafka-esque situation to try and fight.
Yeah, exactly. Because they had done nothing wrong. They were just running their post offices, and suddenly they're accused of all this fraud, thrown into jail, and all these financial issues, bankruptcies, and so forth. Yeah, it's quite it's almost quite unbelievable to think that this kind of thing can still happen in liberal democracy with all our checks and balances. But still the systems failed us, and the Robo-Debt Royal Commission showed as well that the ombudsman, although they investigated, the departmental officials came in and interfered with the report and withheld legal advice from the ombudsman. So even though we have quite sophisticated checks and balances in all these liberal democracies, they still didn't stop the robo-debt for many years until finally it came to the breaking point.
We've got two questions online. Just in terms of robo-debt, Graham, Centrelink does have a flag for vulnerability, right? And they were at some stage not sending robo-debts to vulnerable clients, and then they started. But let's pass it on to Ben. Ben, do your question?
Thanks for it. I was wondering your research, if you'd actually come across any good examples of this, like of automated decision making working properly at all, or is it all bad?
That's a good question. So the happy stories. I think there's certain things that are a lot lower risk in terms of automation. So for instance, beneficial decisions. So if the decision is positive, automating it is less of an issue compared to adverse determinations. And in Australia, the Department of Veteran Affairs has a golden rule for AI, where positive decisions can be automated, but negative decisions are sent for human review. So that reads the positives of AI, that efficiency and cost effectiveness and so forth, but it doesn't lead to the strong risk of the negative determinations being, hundreds of thousands of wrongful determinations. So I think that they can be deployed more carefully than they have in the past, and that will reap the greatest benefits without the significant cost that might happen.
Okay, thank you. There was one other question, if I'm allowed, Paul.
Yeah, sure.
Just a quick one. You mentioned briefly about proprietary IP issues, like with respect to transparency, in terms of like explaining how these things work.
Yeah.
I would have thought there's also like an issue with the actual technology that's being used. So we talk about black box or white box AIs or deterministic, non-deterministic AIs. Is government using these sorts of black box AIs? They all sort of more simple. I think it was a Graham, the lawyer, talking about flowcharts, which is basically just a decision tree model. But
yeah, so what I saw when I went to the US is what I was shocked about was the level of use of AI in government. So it's a lot more pervasive than here. So RoboDebt was an expert system, so it spits out its rules-based when this is the situation, this is the outcome. Whereas in the US, and I'm not sure how much it will spread across the world, the use of AI was including machine learning, the predictive technologies. We're going to predict whether you are going to be a fraudster. We're going to predict whether you're going to be a criminal reoffender. So those kinds of use of machine learning to predict human behavior are a lot more controversial. And they are so widely used across government in the US, like in the Social Security, the whole of the criminal justice system, from bail to sentencing. And that's the black box issue. Machine learning, we can't always open the bonnet and explain exactly how they came about this decision compared to a rules-based system. And the other issue is who made these technologies, who owns the rights to them. So in a very big empirical study of federal government in the US, they found that 50% of government technologies were developed in-house, which means that 50% were developed by third-party suppliers, outsourced, and they just buy it off the shelf, and then they put it in, and then it stuffs up big time, sends hundreds of thousands of wrong death notices, that kind of thing, or predicts completely falsely that you've committed fraud. So I think a very big issue in the future is, who produces that technologies? If you outsource it to a private company, they might not understand how to translate government policy into code, or how the imperatives of technologists are quite different from policymakers. So how do we translate that across? And we see that there's increasing collaboration between government and academia and technologists, where they try to develop it, bring the technologies in and speak to the policymaker and develop it together over time and test it and before you deploy it. So that's a potential solution, that sort of bringing together the different parts, the technologies, the policymakers, the experts, to try to make sure the algorithm is right before you deploy it.
Okay, thank you.
Ryle.
Hi, yes. Firstly, just thank you for the presentation. It was very insightful, and it was interesting to hear the differences between the different jurisdictions. Excuse me. I'm wondering how you think the judicial review courts in Australia, how their approach, you think they might change in the future? I mean, rationality is a fundamental concept over here, but the courts are very much hamstrung by the strict separation of powers and this very rigid legality merits distinction. And I'm just wondering if you think we might see the courts to be willing to be more scrutinous in the future in order to more sort of rigorously address these sorts of issues.
Yeah, that's a really good question. And I'm sort of a bit pessimistic in the courts changing their legal approach, because the way they have interpreted the Constitution over so many years and judicial review has shown a very legalistic, formalistic approach. Like, for instance, when things are outsourced to government, that's outside of statutory judicial review, straight away. If you change the structure of government, the courts haven't adapted to move forward to do that, to expand the definition of what should be a government function. So we've seen a very legalistic approach, formalistic approach by the courts over time. I think our hope is in the legislature for the government to actually put in legislation that might put in additional safeguards, or maybe expand the definition of what is reviewable. So I think the courts will left to their own devices, just keep going in this formalistic and legalistic and quite narrow way. But we do need some form of intervention in terms of, basically new legislation that provides more fundamental protections. We might saw some of that in the European Union with the GDPR, with data protection rights. And yeah, hopefully the Australian government will see the Robodebt situation as an opportunity to amend the laws in some ways or increase safeguards for individuals. Yeah.
Just going off what you were just talking about, do you think Queensland's now got Human Rights Act? Going specifically to the UK example you spoke about, obviously the European Convention on Human Rights has been around a while, and it's a regular part of the UK's courts as kind of the habitual thing to use that. What do you think, what are your views on a potential Bill of Rights in Australia that the Human Rights Commission is currently consulting on to provide protections when it comes to public decision-making in this sphere, as opposed to more public decision-making specific legislation versus a broader human rights Bill of Rights as a safeguard and as an avenue, further avenue for redress?
Yeah, that's a really good question, because when I look at the UK and European cases, yeah, the great avenues of success has been the European Convention of Human Rights in terms of privacy and anti-discrimination. So they have actually struck down legislation, and the Netherlands as well, the right of privacy under the ECHR was breached, and the SIRI, the automated social security system, was struck down as unlawful because of that. And similarly, safeguards were not sufficient in the UK for facial recognition technologies used by the police, and that's been found to be unlawful based on the ECHR as well. But one thing to say is that, so the strong rights-based approach does create very significant abilities for individuals to challenge government decision-making. But the human rights frameworks that we see implemented in Australia are not akin to the ECHR. They're not individual rights where the individual can take a challenge to the Strasbourg courts. What we have is sort of an inter-institutional model of rights that we see in Victoria and Queensland and the ACT, where the courts can't invalidate, then they just declare incompatibility. Then it's up to the legislature what they do. And that's a lot weaker than saying, I as an individual have had my right to privacy breached. I'm going to go to the European Court of Human Rights to litigate this and seek individual redress. So so depends, yeah, so it's good that the government in the federal level is looking at a more general federal Bill of Rights, but if it goes down the same path as what we see in other models in Australia, that won't really rectify government AI decision-making. But yeah, when I go and look at the UK and EU examples, the ECHR has been a very strong avenue for individuals to challenge AI decision-making very, very successfully as well. Like it brought down the whole program in the Netherlands.
I've got 3 questions. I'm sorry about that.
Yeah, sure.
They're really fascinating talk. And the first one, I guess, following up, you mentioned SIRI in the Netherlands. And the key thing about SIRI, which is different to the ones that you talked about, is that the technology wasn't part of a decision. It actually was leading administrators to investigate people who are seen as high risk of fraud. And we see this use of digital technology. We do use it in Australia in our tax systems or our tax returns to identify whether to investigate certain things. And this is what I would say subterranean to actual government decisions. And so our administrative law decision system deals with decisions of government, but when we're actually using technologies which actually underpin investigations, they're actually not appellable or reviewable because there actually is no decision to appeal. Now, in the US, I think it's the 4th Amendment, correct me if I'm wrong, where people have asked the question whether actually these kind of flagging of potential breaches of certain things might breach the 4th Amendment. Is that the right to unfair investigation. Is that right? Is that the Fourth Amendment? So I'm wondering where law fits into this, because I mean, the point about Syrie is that that used the human rights because it was like you couldn't use administrative law. So that's the first question. How do we deal with those types of uses of technology? The second question is, as you mentioned really clearly about the Australia approach is really addressing administrative law, but administrative law is based on individual decisions. I will appeal my decision and you will appeal your decision, but we have no mechanism to actually appeal the structural decision tool. And my question is, do you see capacity or legal reforms that would be actually allow us to appeal the decision system as opposed to the individual decision? And the last question, which I think bring up, which relates to this also, is this murkiness of the legal setting of administrative of automated decision making. As you mentioned in your talk, there is a lot of deeming provisions where it says that the secretary can delegate to a computer to make a decision, but we have that tax case which has overturned the idea that you can do that. And so there's a lot of debate about whether that decision in the tax law in the tax case was actually useful, because it kind of undermines the capacity to actually use automation for making decisions at all. So I'm wondering, where do you see that might be going in future? Sorry, there's a lot there, so I can repeat questions if you want.
Yeah, might need some reminders along the way. Yeah, there's only so much brain capacity here. I'll start, and then if I forget, people can prompt me. So I'll go to the last question first because it's freshest in my mind. So the Pintarich case basically said, okay, a decision requires, under the Administrative Judicial Review Act, ADJR Act, requires a process of deliberation. And yeah, therefore, an automated decision might not be a decision under the Act. But this actually benefits government, because if you can't challenge a decision through the ADJR Act, like an automated decision, because it's not a decision, then very few government decisions would be able to be challenged based on that kind of reasoning. So Pintarich, I think, is a really big misstep by the judiciary. But then when it was appealed, it was refused special leave. So this is the final word at the moment that we have on the issue. And I think that's very problematic and does need to be overturned at some point, or legislation needs to be put in to ensure that we do have statutory judicial review for automated decisions. It's a very bad precedent, in my opinion, that does need to be addressed at some point. So remind me the other ones.
So the other one was about how do we address in administrative law the structure of the decision-making systems when the decision-making structure is systemically erroneous, as opposed to the decision about me.
Yes, so that's
the only thing we could do we had individual going into the federal court, but then we'll have a class action, which basically was saying we all agree that this system's wrong, but we don't actually have any capacity to legally challenge the decision-making system.
Yeah, exactly. So we do what we ultimately want is the automated system to be amended or reversed or whatever, rather than just one decision out of 400,000 is corrected. But yeah, that's a feature of our legal system. And that's what the Robodebt Royal Commission found in terms of the tribunal decisions on individual decision makers. So they said, okay, that, we're going to waive it. We're going to waive this, that. So there was just individual decisions that said, and I think Terry Carney, as an AAT member, said this system is actually unlawful, but was ignored completely by the government. So we've got all these individual decision makers at the tribunal level, at some extent to the court level, which make determinations based on whoever brought the case. but we don't have a ability to say the whole system is wrong. We have to take down the whole automated system. We have to amend it in some way.
So I guess my question is, do you see any legal reforms that might be able to challenge a code or an algorithm?
Yeah, potentially. So what we see in the other countries is also individual challenges, but then in America, constitutional due process required a level of disclosure and then ongoing supervision by the courts to see whether they have amended their formula. So that kind of situation might be quite helpful in this instance, where the court actually sees whether the government follows the determinations over time, over several years. So that's quite a good mechanism. Another mechanism, as you said, is the class action, where you have, 400, 6,000, 100,000 people bring the claim and say that this whole system is unlawful.
Well, it's an old question. I'm sorry, I'm jumping over Kobe. An old question for law, the question of dealing with systemic risk, the common law of torts, you sue your individual accident, there's no learning systemically from that. And then we bring in the Workers' Compensation Commission and rehabilitation, use insurance model where employers then have traditionally in public law, the idea where you have integrity agencies like the Ombudsman, but they're oily rag kind of stuff, and they do have powers to make systemic investigations. Sure, Holmes will have things to say about the Ombudsman's role here. Auditor General, similarly, privacy commissioners and so on, but then you're sort of worrying, oh, fourth branch of government, you've got these big, they become almost too interventionists, and have they got the right skills? So then you start to think, well, maybe we need to think about it less in terms of that kind of ombudsman integrity approach, and maybe what kind of experts in AI and automated decision making need to have a holistic approach over government, be going through an auditing and looking at with ethicists by their side. Maybe that's another model, but.
Yeah, my sort of model for the book was legal, political, and managerial controls, with legal controls actually being the last resort. So because once you've deployed faulty technology to 600,000 people, that's actually too late. So for me, I think the controls have to start at the department or agency level, the managerial controls, in terms of how they procure the technology, design it, deploy it, and how they audit it. So my book will focus on, the internal agency controls that are needed. And we see that happening at a sort of organic level in the US, where the government is starting to talk to the NGOs that are bringing all these actions. There's a lot of legal actions at the state level challenging all these various algorithms. So they're starting to talk to them and say, okay, what's wrong with this algorithm? And the NGOs are teaming up with technologists to test the models as well. And so we can see this happening, that when you develop the algorithm, it's very important to bring in the experts, the technologists, the policy people to make sure it's designed correctly in the first place. And that second element was what Graham talked about, the political mechanisms of control, where we've got the Ombudsman, Auditor General, parliamentary committees, information commissioners. They play a very strong role in the oversight and transparency and bringing things to light. And yeah, at the last resort, we've got the legal controls, individuals challenging government action. And the very, very, very last resort is the independent inquiries like the Robo-Debt Royal Commission and the Post Office Scandal Inquiry, where we want to figure out what has gone wrong, like who should be held responsible, how do we stop this from happening again in the future? So I think to have the broadest protections, we do need that full spectrum of legal, political, and managerial controls. So that's sort of the proposal in my book.
Kobe, I'll delay my third question to Kobe. Thanks, Kobe.
Sorry, I can't see who's speaking. Who's that who just spoke? Because I fully agree with what you just said.
Is that Paul or me? It's
both of you.
Paul.
Okay, awesome. Yeah, I just wanted to sort of add to that, because I don't know how many people in the room are lawyers, but I think there's often a tendency for the lawyers to just always go back to the law and look at the legal. And I say that as also a reformed lawyer, being a reformed lawyer. But I think what you were just saying then is actually really important, that there's a whole toolbox of things. And one of the really important things is not to just fall back on law all of the time, because every time law gets involved, there's already harm done, and there's a lot of harm that can be done, as Ed Santo used to say, in a short period of time with these sorts of systems. So things like going back to principles, the 2004 principles that were already in place that the government had, that sort of had, to your point, if you make a positive decision, that's okay, but if there's a negative decision, it needs to be reviewed by a human. Those are things that were thought about by the government and already in place in 2004. And so Robodebt actually overrode and ignored those as well, for those who aren't familiar with that. But the other thing I just wanted to mention that it hasn't been mentioned yet is standards. So the AI management standard, for which I have to sit as an expert, is coming down the next couple of months. And that actually provides processes. Again, it's too late to review at the end. You actually need to review platforms, and that includes third parties, not just individuals, but third parties at the point of acquiring or building them, not later on. So all of those assumptions that are built into the data sets, the algorithms, and they don't need to be complicated. You can have really simple algorithms like Robodebt causing incredible harm. And then the final point I wanted to raise is culture. We haven't really talked about that, but when I talk to public servants, I mean, the main message they get out of this, or that I keep hearing, is we don't need to speak out. We can't speak out anymore. So I think that the silencing effect of Robodebt, regardless of what the outcome of this commission is still incredibly profound. Public servants feel incredibly disempowered and unable to speak out because they tried. Many of them did try during this process. And I think that's a piece that if anyone's doing research on that, I'd love to hear more about. I think the cultural piece is something that's often overlooked in all of these conversations. But thanks for a great presentation.
Yeah, thanks, Kobe. And that's a really, really great point about the culture of the public service. So we've seen basically a fundamental weakness in our system of public administration, where the senior public servants are on fixed-term contracts. They are afraid. They are no longer frank and fearless. They are afraid of speaking out, and yeah, the power and influence of the public service has been greatly undermined. I've written about this with the influence of ministerial advisors. The public service has become sidelined and disempowered and weak. We've got a weak public service now that doesn't stand up to its political masters, as we've seen in this Robodebt situation, where these public servants misled cabinet, they hid legal advice from the ombudsman. It was actually, yeah, quite a shocking read when you look at the level of
yes, and it's not limited to public service. Unfortunately, corporates are no different. So you also have executives on short-term incentives. So this comes back to the KPIs and the culture, that if there's not a disincentive, legal action is so far down the road and they're usually gone. Even risk owners in large corporations are usually gone by the time the risk lands. So that's just so that we don't just think it's about government. I know that's what your presentation's on, but it's actually across the board. This is an issue.
Yeah, it's definitely a human thing, but I guess, yeah, I'm a escaped public servant myself, not reformed, just escaped. So when I was in the public service, I saw all of that, the managers being really proud if they misled a public parliamentary committee, the ministerial advisors trying to subvert FOI processes, and successfully, instead of putting it in the legal branch, they moved it to a government branch where no one was a lawyer, and therefore they could just get whatever they wanted done. So this is a systemic issue, I think. I can't speak for corporations, but certainly in the public service, this desire to conceal, to try to look good to the political masters, to play politics and to try to win in the game of politics or rising to the top, that kind of thing. And it's something that we haven't addressed for many years. It's something that's become worse and worse over time, and the Robodebt Royal Commission threw that really in stark light, that the courageous public servants who speak up are ignored and sidelined. Their careers are jeopardized for speaking out, and that creates a culture of people a lot of yes people. And the cynicism as well at the ministerial level, the political level, of saying, okay, I'm the welfare cop and I'm going to be tough on all these fraudsters, and that using of welfare, targeting sort of minorities for political gain. and coupled with the fundamental weaknesses in our system of public administration, created this very huge, large-scale problem that has damaged a whole lot of people's lives and also damaged everyone's faith in government now.
Even a step further, just to be slightly provocative, academics were particularly silent on this issue. It's easy now, post the event, for us to be critical. But at the time, and there's a little bit about this on some of the social media stuff, you know, certain people were very vocal, but a lot of academics didn't dare speak out either, because ARC funding is affected by what you say publicly. And they didn't, this is one of the reasons I was told that so few academics didn't speak out, because there's so many legal implications to this form of decision-making, to your point, Pintrick, but also the reverse onus on the individual to prove the debt. So many lawyers knew it was wrong, but academics weren't emboldened or culturally fearless either. There's a general issue, I think, that goes beyond just the public service, but I'll leave it there just to be provocative.
Yeah, sure.
Kobe, I'm not quite, as someone who applies for ARC grants and been quite successful, I don't know that's really a problem of speaking out myself. I mean, for me, this is something I've studied for many years and worked in the public service too, where I was told I asked too many career limiting questions. That was the term they used. I think there was a sense of hopelessness that you could see that no matter what you did, and it goes back to culture, nothing was going to change what the government was doing. And this goes back to the layers of governance. It's all very well to have these layers of governance, but if you don't have goodwill, if you have institutions that manipulate the review processes, ignore the tier 1 AAT reviews, and refuse to go to tier 2 AAT reviews, decisions are public, where you wipe debts when they come to the federal court and say, hey, we don't have a space to answer, when you provide misleading information to the ombudsman, all of those processes undermine it, like in parliamentary inquiries, everything. It's like, well, what can you possibly do here? And I think that's where, for me, the law has to be the benchmark, because that's the only way you can potentially get government to do something. And I think the huge difference in culture is so striking when you look at the Syrie case in the Netherlands, where the whole cabinet
exactly. And this was
designed. And yet you've got Morrison here and Dutton basically dismissing of the whole thing now. It's disgraceful, really.
Yeah, I feel like a free agent as an academic, again, being an escaped public servant where you can't say very much. But yeah, I feel quite free to express my views, including being very critical of government. If I was in like China or Zimbabwe, I probably feel differently as an academic, but I think in Australia, I do feel I've got academic freedom to express my views. And certainly Terry Carney, who was quite prominent in the Routledge Royal Commission, did write papers and give talks about the scheme being unlawful after his appointment as AAT member was not renewed, possibly political reasons, not sure. But yeah, certainly.
There were some, I'm not saying there were none, but I think it's another thing to unpick, because I think there were fewer than there should have been, given the scope and scale of the harm caused.
One of the questions for me that came up when you were talking about is like, how much of this erroneous use of computers comes back to an assumption that computers are always right and that people just rely on that? And I'm wondering whether that underpins like the robo debt. I mean, people, they kind of hid it in terms of what was doing, but they're like, well, okay, I don't understand it, I'll just assume that it's right. In the Postmaster General's case in the UK, it was kind of like, well, even the courts, where they didn't actually investigate in detail before they actually convicted people to see whether the computer was right in its decision making. And I'm just wondering, to what extent does this assumption that computers are always right underpin some of these problems?
Yeah, definitely. There's some studies to show that automation bias, that when the computer makes a decision, the human would tend to follow it. So even with AI-assisted decisions, where the human makes the final decision, they certainly are influenced by what the computer comes up with, and they might be scared to go against what the computer actually says So there are actually studies that show that, yeah, there is a bias towards accepting the computer's recommendations. And yeah, certainly for vulnerable social security recipients. And even if I got told I'm owed this amount of money, it'll be hard for me to try to figure out as a lawyer, not a maths person, how much I actually owe. So yeah, it's reliant on the computer being right, which we've seen isn't necessarily the case for all these different case studies.
It's a culture. There's also a capacity issue and problem, because I think a lot of us who might have worked in government, as I have, as well as in law and so on. I've got a maths degree, but I sit on the New South Wales Electoral Commission vote panel, and I really, really struggle to even begin to understand some of these reports that the computer science guys are putting out, and other outsiders are critiquing the system, because that's seen as a proprietary technology, and there's been issues with it and so on. And then within government, often the default is, well, you just outsource to PricewaterhouseCoopers. So on. And we're all hiding the fact of our own lack of capacity. And that can apply also to the IT guys who work, and women who work in a very, very, very fast moving and complex area. They're not going to be necessarily understanding of the concept of rationality in law. They have a certain view of logic within computer programs. So that's kind of a brave new world, and that's why I think you need an agency where you bring together people who've got both sides of that brain.
Yeah, exactly right. So yeah, there's US people have written on this, that policy by procurement. So you're sort of devolving the responsibility to technologists to figure out all these policy rules and code them, turn them into code. And IT people are normally not policy people. They might not understand the departmental policies or goals and so forth. Unlikely they would be that kind of person. If you buy it off a shelf from Deloitte, it might not be suitable for that exact agency use. Rhode Island, for instance, bought a piece of technology from Deloitte and just plunked it in. Everything went wrong, and then, Rhode Island then sued Deloitte, that kind of thing. So what we're seeing is this new age of technology coming into government, but government's not quite at the stage where they have figured out how to implement it properly. And that's why those controls are really needed.
Oh, go on. Last one. We got one more question.
Just a point before about automation bias. I guess my understanding after reading quite a little bit about this is that automation bias isn't too prevalent in government. It's more so a deference, an aversion to automation. Within the research that you've done, have you found more of an attitude towards bias or aversion at all in government?
I haven't looked at officials' attitudes to government. I've more looked at the sort of legal systems, political controls, managerial controls. So I've seen studies that have said that there's a bias to accepting what the computer says, but I haven't personally gone out and surveyed government officials. If I get a giant pot of money, maybe in the future, but that's something that we don't have a really strong handle of. And we don't know how much automation and AI will come into government here compared to the US. If we have the US as a benchmark, it will be quite pervasive in all aspects of government and the criminal justice system. And we do need to ensure there's appropriate safeguards. Yeah.
Thank you very much, Yee-Fui. Can you please join me in thanking you for a fabulous, stimulating and really interesting topics.
Thank you.
Just in terms of culture, some people may be interested in reading Professor Andrew Podge's report to the Royal Commission Andrew Podger was a former Australian Public Service Commissioner and a departmental secretary. He was actually commissioned by the Royal Commission to write a report. It's not in submissions tab, it's actually in publications. So it's about 42 pages long, and he talks about the nature of the public service and very much about appointments of senior executives in there. The other thing I should mention before everyone goes is tomorrow morning and from 9 o'clock for 4 hours, we're running an event in Sydney, but it's also online called After RoboDebt, the role of civil society, the media, and the public service, law and public service in ensuring government's use of automation is ethical, responsible and accountable. So I can post that in the link in the chat before we go, if anyone would like to do it. And thank you very much, Kobe and Ryle, for your suggestions, your comments as well. So I'll just anyone who wants that information about tomorrow's event, I'll just post that now.